Good afternoon. I'm Judge Leslie Kim Smith. We are now live streaming on YouTube and on the record. Calling case number 240126008NI, Stephen Young versus Citizens United Reciprocal Exchange. Counsel, will you place your appearances on the record starting plaintiff's counsel?
Allison Lizette appearing on behalf of plaintiff.
Each Shabbat's on behalf of defendant EQ.
Mr. Berry?
Mason Berry on behalf of Groesbeck Pharmacy.
All right. Today is the date and time for the court to hear oral argument on defendant Citizens United Reciprocal Exchange motion for partial summary disposition. May the record reflect I've had an opportunity to view the pleadings, and if you're ready to proceed, you may begin.
Thank you, Your Honor. I'm not going to reiterate everything in my motion. I do want to note that in this matter, plaintiff Stephen Young has a long-standing history of disc bulges, herniations, annual tears, bilateral hand injuries, and a torn rotator cuff, which is important to note as he has undergone several MRIs in the past, including in October 2023 MRI of the lumbar and cervical spine that showed the very same disc herniation that was seen in the MRIs from 2012. The EMG that was taken after this accident also showed the same diagnosis from 2012. There has been no difference in the MRIs or the EMG findings as well between a 2012 diagnostic imaging and the imaging that was taken after this accident. And just because, a condition temporarily follows an event is not evidence in itself that it's caused by the accident based on the objective findings in his MRIs and medical records. In addition, both IME experts, Dr. Boji and Dr. Khalid, in review of all the imaging that was provided to both of them, both before the accident and after the accident, both indicated that there was no new traumatic injury causally related to the accident that we're here for today. That was on September 8th, 2023. In fact, Dr. Khalid noted that there was a tear in the left glenoid labrium and paralabrium cyst, which is indicative of a long-standing chronic tear that would have taken years to develop, not something that could be traumatically caused as a result of an accident. As for the effect of his life, Your Honor, plaintiff's testimony confirms that he had continued independence. He continued to drive himself to appointments. He moved residencies. He continued his gym membership. In defendant's motion, there is surveillance that was taken that showed that he's perfectly capable of deadlifting quite heavy weights, deadlifting them, lunges, all of that he claims that he couldn't do even to that point. At the same time that surveillance was taken, he was reporting to our IME experts that he couldn't do anything, that anything he tried to do, if he tried to lift anything with his arms, with his right hand, he would feel numbness and immediately have to drop it, which is completely inconsistent with the surveillance that showed that this man can, lift very heavy weights and be able to do that with no issues. Our surveillance did not find him dropping anything despite his claims that he has right hand issues. He could also shovel snow, which we know how Michigan snow is, perform yard work, take out the trash. Based on that and, the Court of Appeals opinions in Essex, Fuller, Harmon, and Lingenfelter that have stated that, that due to the complete lack of threshold injury, this court should also find that there is a complete lack of records reflecting any objective changes that had occurred as a result of this accident that are different from his freestanding diagnostic imaging that was taken before this accident, and find that Mr. Young did not sustain a threshold injury.
All right. And in response?
Yes, thank you, Your Honor. Our client, I want to note first of all that his deposition was almost 2 years following the accident, and all of the surveillance previously mentioned was also following the deposition and following his testimony in this matter. So anything he testified to, and anything seen on surveillance do not necessarily correlate because the surveillance was all done following his testimony in this matter. Next, I want to point out that counsel's comments about anything he said to the IME doctors is hearsay and inadmissible, as I know this court is well aware. Nonetheless, that defendant's own IME doctors did find that he had not reached his pre-accident status and that he continued to be disabled as a result of the motor vehicle accident and that he had not reached maximum medical improvement related to the accident. That was Dr. Michael Kizzy, which is our Exhibit 11. I've also documented in my response multiple sets of records in which his treating physicians relate his injuries, his tear, his carpal tunnel diagnosis, all to the motor vehicle accident that occurred on September 8th, 2023. The fact that he may have had some injuries before the accident, there's clearly objective findings and diagnoses that are only related to the September 8th, 2023 motor vehicle accident, which we've documented in our numerous exhibits, including muscle spasms that are objective under the Michigan Court of Appeals opinions, as well as yellow discharge in his thumb and pain, swelling, and bruising in his hand, which did not exist before the accident. Furthermore, our client testified that he was able to work before the accident and was not able to return to work following the accident, all of which was supported by his treating physicians and our exhibits to our response. I'd be happy to answer any other questions, but that's my response at this time.
All right, is there a reply?
There is a reply, Your Honor. I do want to note that while there was one IME doctor, Dr. Kinsey, that did state that there was further treatment to be had, there were additional actually 4 other, my apologies, IME experts that stated quite the opposite. And in fact, there was a hand surgeon, Dr. Stephen Kushner, that opined that there was no impact to plaintiff's hand as he suggested. There was no fractures in his hand. It was minor swelling that went down pretty quickly after the accident. There was nothing in his any of his diagnostic imaging, any of his medical records that showed that this individual suffered a hand injury as a result of this accident, as well as the shoulder injury, neck injury, and low back injury. That again is not any different than what his imaging and his medical records showed before the accident.
All right. May the record reflect I've had an opportunity to listen to oral argument. Plaintiff filed this action on August the 30th, 2024, seeking first-party no-fault benefits as well as UM/UIM benefits from defendant Citizens United Reciprocal Exchange arising from a motor vehicle accident that occurred on September the 8th, 2023. Defendant Cure filed this motion for partial summary disposition pursuant to MCR 2.116C10, arguing that plaintiff has failed to show a serious impairment threshold injury. Therefore, he would not be entitled to UM/UIM benefits. Defendant cites to that plaintiff did not report any injuries at the scene of the accident. There was a hand x-ray that was negative. Disability and replacement service slips were backdated. Wage loss was dismissed by stipulation. That the plaintiff was captured on surveillance video performing normal functions with no apparent disability. That plaintiff was involved in a motorcycle accident in 1998 and injured his left hand and right arm. He was also involved in a motor vehicle accident in 2012 and claimed injuries to his back. As such, defendant also cites to another number of IME doctors and reports indicating that there was no objective finding of injuries as it relates to this motor vehicle accident. Now, plaintiff in his response argues that he sought treatment 10 days after the motor vehicle accident, that he went to the urgent care physician, and in that physician found positive findings of tenderness and muscle spasms in the cervical and lumbar spine, as well as swelling and yellow discharge from his hand or thumb area. His primary care physician also found objective evidence of injuries, finding a decrease in range of motion. There were IMEs, there were MRIs and EMG tests that revealed abnormalities in the test results. Plaintiff also argues that the injuries he sustained in the subject motor vehicle accident affected his general ability to lead his normal life, that he's unable to work and needs assistance from his fiancee for household chores. Now, in defendant's reply, defendant indicated that the plaintiff drove himself home. He was treating with PIP-friendly providers, and that a number of IME doctors found no impairment. Well, as you all are aware, the impairment doesn't have to be permanent, nor does it have to be devastating to the point where a person is unable to leave his bed. In this case, it's clear that there are questions of fact. There are multiple experts that have contrary opinions in terms of whether or not plaintiffs suffered objective evidence of an injury. So for those reasons, the court is going to deny defendant's motion for partial summary disposition, finding there remains a genuine issue of material fact as to whether or not plaintiff suffered a serious impairment threshold injury. So your motion for partial summary disposition is denied. I'm going to, unless there's anything that anyone wishes to state